chat's got soul. From the gavel to the gas, we're watching it all. Covering the courtroom, big case or small. Laugh when we can, cry when we must, but it's all real talk, you can count on us. We're not the pros, just fans who care. With popcorn in hand and a comfy chair. And every twist, we're right there. Together like we're all in the witness chair. This is the Broken Banter, where the trials come alive. Where the chat is wild and the vibes survive. We're watching the worst of what people do, but we keep it light, yeah, that's our truth. It's the only place for crime, and it feels just right. We bring the justice talk into your night. So hit that stream, don't miss the call. At the Broken Baker, we cover it all. Oh yeah. We're just laymen with the view, but we ask the things the world wants to. Digging through the facts, side by side. Even when it's dark, we bring the light. No clickbait, no fake feels, just truth and the highs and the reels. With the chat that roasts and rides, we're just here for the case and the vibes. This is the Broken Banter, where the stories unfold. With a smile in the heart, even when it's cold. Yeah, we cover the bad with a wink and a grin. Where the real talk starts, come on, jump in. It's the only place to be, can't you see? For trials and truth, it's BBTV. The Broken Banter, where the trials come alive. Yeah, we'll be here, trial of the trial. Yeah.
Hello, everyone. According to Kathy Russo, things might be happening. There could potentially be a verdict. It could be that, I don't know. But apparently the courtroom is filled with people, and that should be an indication that something is happening. Verdict or hung jury poll? Jim Cox, thank you for 15 months, and you got your poll. Jamie is here, but she doesn't want to talk to you, Danny T. She's mad.
Hi.
Oh, didn't want to talk to her, but not me.
No, I was just muted while you did your thing. I was tip-tapping on my computer. So.
I don't know if they are in the court. I saw that the family in the Koberger, Koberger case, the Gonsalves family might. Oh, there's Kathy Russo says there's 10 deputies in the courtroom. This normally signals a verdict. That's 15 minutes ago. So they are probably about to go live. But the Gonsalves family, who raised money to be in the courtroom against Koberger, are talking about refunding the money that they selected. I know, Sue, you hate me. How's your bossy buddy? Well, they were kind of calm, so I needed to put up my enclosures because I have a four-legged friend stopping by the next week. So I had to make ready for that. And I got that done.
Put your little gate up. Is it Monty?
No, it's Molly.
Oh, Molly. I miss Molly.
Yeah, maybe she'll remember who I am.
Whatever.
Well, I haven't seen her in... Oh, that's been a long time since I've seen her. No, I didn't kill the wasp. I can't figure out where the wasp nest is. It seems like and these are not ground wasp, but it seems like they're living underneath a floorboard in my shed. So,
Oh yeah, they will do that.
Yeah, but it's just like at the entrance there's like a 2x4, and it seems like they're living down there because when I went in there earlier today and I saw they were swarming, I was getting my burner to get rid of some weeds. So I just gave them a lot of gas in there, and then they kind of
They
The
wanted
jury is
to
as
kill
hung
her.
as Lefty. That's not much. She never really pooped inside of my house. I think she might have done it when she was a little baby, but other than that, she's been pretty good. She'll come in and tell me. Funny thing is, even though the last time she was here for a week, I put up the fence out in the garden. She doesn't really want to go there. We have a park up behind where I'm living, and she want to go poop on that grass.
Usually, once you walk them around, then they'll.
Yeah, but it's just annoying if she wakes up at 2 a.m. and want to go to the bathroom and she doesn't just run outside.
You know.
That's a little annoying. So yeah. Are they Swedish wasps? They could be because they're yellow, just like the Swedes.
Are they wasps or are they like those nasty bees that are mean?
Bees don't sting.
Well, there's so many different kinds. Yellow
No.
jackets, is that what I'm thinking of?
Well, bees are the ones who die if they sting you. So they will only do it if you provoke them. These are wasps, and I think they'll die as well, but they are crazily aggressive, and I'm allergic to them.
Yeah.
So that's a
Well, just
little.
around here we have
misfun.
like the black wasps, and then we have the like yellow jackets, and then we have like the little bees. And I don't mind the bees. They don't bother you too much.
Well, we'll figure out. I've been looking at this all day, and I'm just thinking, is anything happening? Because this is 15 minutes ago. At least come back and say something.
Yeah,
Oh, the
surprisingly,
wasp keeps their stinger.
yeah, the one wasps, they just keep going.
Yeah, and those are the ones that I'm allergic to all stings, but honeybees don't sting you as long as you
Yeah,
just
they're
leave them alone.
exactly.
And the
And
big
like those
ones,
big fat bumblebees, oh, they're so cute.
yeah.
They'll just land on you and they don't bother you. I don't mind those ones either. They're really
No,
cute.
I don't. I have a guy at the gym who sells honey as well. But stay away from them, and they don't hurt you.
Yeah.
Mhm. No update.
Murphy presiding. Good afternoon, Your Honor.
Good afternoon. Good afternoon. Good afternoon, everyone. You may be seated. Thank you. All right. So we're back on the record in the matter of State of Connecticut versus Raul Valle Valley. I'd ask counsel to please identify themselves for the record.
Good afternoon, Your Honor. Mark Dorso for the State of Connecticut.
Good afternoon, Your Honor. Tatiana Messina for the State of Connecticut.
Good afternoon, Your Honor. Kevin Smith for the defendant, Raul Valle, is at my side.
All right. So, counsel, as you are aware, we have received a note from the jury which indicates that the jury has reached a partial verdict. And when I say partial verdict, in summarizing the note, which does indicate to some extent the deliberative process, it appears that the jury has reached a verdict as to murder at count 1, manslaughter in the first degree intentional at count 1, assault in the first degree intentional at both counts 2 and 3, and assault in the second degree intentional at count 4. At this time,
What?
the court's intention would be to accept the partial verdict and declare a mistrial on any lesser included charges upon which the jury is unable to reach a verdict. I will note that the note additionally indicates that after lengthy deliberations, the jury is hopelessly deadlocked on the other charges. So I would give each counsel an opportunity to be heard at this time. I'll stop.
Thank you, Your Honor. The state would be requesting that the court now at this moment give a Chip Smith charge to the jury. They've been out 2.5 days now, I guess, a little over 11 or 12 hours. There were 25 witnesses that were called in this case.
No, they've been out for
There's a mountain of evidence
14,
that
15
needed to
hours.
be reviewed, and we went from hopelessly deadlocked after an hour and 45 minutes to now having a partial verdict. So I would submit that perhaps there'd be, if the court was inclined to give that Chip Smith charge, that they could go back and maybe come to a decision on the charges for which they are deadlocked.
It's the Raul Garcia.
Your Honor, the defense would object to a Chip Smith at this point. The court has already twice sent them back with essentially a Chip Smith light sort of instruction on the basis of Feliciano. And I think that the jury has indicated now on a number of occasions that they are rather hopelessly deadlocked as to those charges, which they still cannot come to any resolution on. My understanding of the note is simply that giving them another charge is not going to change that, and so we would object.
So in response to the request for the Chip Smith, which is basically another attempt at the court to ask the jury to continue its deliberations, the court is hereby denying that request on behalf of the state. In keeping with Feliciano, this court has not once, but on 2 occasions provided a chunkier or a wider Feliciano charge. On day 1 of the jury having this case, the court received a note that it was hopelessly deadlocked on the murder count. The court, upon agreement with counsel at that point in time, instructed the jury to continue deliberating. At that time, I instructed the jury to review the evidence, discuss and consider the opinions of other jurors, to explain the views and listen to the views of other jurors, including the majority, to listen to what the minority had to say, as well as the minority to listen to what the majority had to say. Subsequently, on day 2, after about 5 hours of continued deliberations having passed, the jury did send a second note indicating the following: that the jury was deadlocked on murder at count 1, indicating that the jury had reached a verdict at count 2 and count 3 as to assault in the first degree, deadlocked as to lesser included charges, and with respect to the last count, count 4, again indicating a possible verdict as to assault in the second degree, intentional, but deadlocked as to the first lesser included charge as well. Once again, that note was discussed with counsel. Once again, upon agreement by counsel, the court extended to the jury another Feliciano type of charge, which included more language than the standard go back and deliberate charge. The court once again looked at the jury and instructed the jury to continue deliberating, to review the evidence, see if any evidence was overlooked, make sure that no evidence was misunderstood, and to explain the views and listen to the views of all other jurors. The jurors did continue their deliberations, and they did review some evidence, which we came back on the record to produce for them. So at this point in time, the court is not going to go ahead and give them a third instruction to continue the deliberations. The court is going to accept the verdict.
And just one more thing, if I may put on the record, Your Honor, with regards to the court's intent on declaring a mistrial on the remaining charges that do exist, the state's intent would be, if that were the case, that we would be filing an amended information to include those charges.
All right, well, I don't know when you would be filing that amended information, but we're going to accept the verdict before any amended information is filed.
Thank you.
Nothing, Your Honor. Thank you.
We have a verdict. We're going to take that verdict. Does anyone else have anything else to say?
Nothing from the state, Your Honor.
Not from the defense.
All right, at this point, we'll bring the jury in, please.
So
I don't really understand.
I think that they are hung on the charge about murder or manslaughter, and
Yeah.
they have an agreement on the assault charges, either guilty or not guilty, because
That's
they're
what it
talking
sounds
about the lesser included. It's really weird the way she phrased it, but let's hear it. I made a quick poll. Jim Cox. Guilty manslaughter is what Chad believe, and Hong comes after that one. Not if she excludes them. Let's see. I am confused at Red.
All right. It appears as though all of our juror
No, because you
members
mentioned
are
both
present.
murder and
Counsel
manslaughter.
Stipulation as such before I begin.
State will stipulate to the presence of the jury, Your Honor.
Defense stipulation, Your Honor.
Oh shit!
So I first would like to inquire as to the foreperson. The foreperson, please just stand. Thank you. All right, so Mr. Foreperson, I did receive the note that was signed by you, and it was timestamped as well. The note indicates to the court that the jury, although unable to unanimously agree on some charges, has unanimously agreed as to a verdict on murder at count 1 and manslaughter in the first degree intentional at count 1. Also, as to counts 2 and 3, the jury has a verdict on assault in the first degree intentional. And then lastly, as to count 4, the jury has reached a verdict as to assault in the second degree intentional. Is that correct?
Yes, Your Honor.
All right. So at this point in time, I would ask you to be seated.
It's because she reads it weirdly.
All right, the court at this point in time is going to move forward with the verdict that you do have relative to.
No,
the
because she
counts and the
mentions
charges
manslaughter
that you
right after.
have relayed in the note and that you have just confirmed on the record. So Madam Clerk is going to be providing to you additional instruction as she accepts that partial verdict, okay? Thank you.
Ladies and gentlemen of the jury, as your names are called, please indicate your presence by answering here, rise, and remain standing.
Yeah, mute that. She reads the charges. So to me, I get it that they can't decide on murder or manslaughter intentionally, and that's what she said. She's gonna. No, Jamie, you can't both murder and manslaughter.
No, that they came to a conclusion on those ones.
Yeah,
The
which
unanimous.
means they are hung, because she said they came to a conclusion on all 4 charges, but the only one she mentions is murder or manslaughter.
Identify himself for the record.
Yes, here. James Stone.
All but the foreperson may be seated. Mr. Foreperson, in the case of State of Connecticut versus Raul Valle Verdict, has the jury agreed upon a unanimous verdict as to murder at count 1, manslaughter in the first degree intentional at count 1, assault in the first degree intentional at counts 2 and 3, and assault in the second degree intentional at count 4?
Yes, we have.
Will the defendant, Raul Valle Verdict, please rise and face the jury? Do you find the defendant guilty or not guilty?
Not guilty.
I'm sorry, hold on a moment. We have to go through the docket number 8.
Not guilty.
No murder.
Sorry.
It's okay.
In docket number AAN CR 22-0189-418T, count 1 of the substitute information charges the defendant, Raul Valle Verdict, with the crime of murder in violation of section 53A-54A paren A of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
No.
As to count one of the substitute information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of section 53A-55, paren A, paren 1 of the Connecticut General Statutes, do you find the defendant guilty or not guilty?
Not guilty.
Okay, Madam Clerk, please pause. All right, I'm going to direct the court's inquiry to the foreperson at this time. Mr. Foreperson, your note indicated, and that's Exhibit 10, Court Exhibit 10, your note indicated
Wow.
that the jury,
Wow.
after lengthy deliberations, was hopelessly deadlocked on manslaughter in the first degree reckless in violation of Connecticut General Statutes 53A, 55A3 as a lesser included offense at count 1. Is that correct?
Yes, Your Honor.
All right, so you were unable to reach a unanimous verdict as to that particular charge, is that correct?
That's correct.
Clerk, please continue on with count 2.
Count 2 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, Court Exhibit 10, again, the note that was sent to the court, provided to the court and marked, indicates to the court that after lengthy deliberations, the jury is hopelessly deadlocked on the charge of assault in the first degree reckless in violation of 53A-59A3 as a lesser included offense at count 2. Is that correct?
That's correct.
All right, so you were unable to reach a unanimous verdict regarding that particular charge as a lesser included offense. That is correct.
That's correct.
Thank you. Madam Clerk, please continue on to count 3.
Count 3 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause.
Jesus, this kid is
Again,
lucky.
Mr. Foreperson,
You got lucky.
Court Exhibit 10, your note to the court indicates
They find him
that
not guilty in
with
everything
respect
that's
to
intentional.
assault in the
He
first
can't be
degree,
retried for murder or
reckless
manslaughter.
under count 3 after
Intentional.
lengthy deliberations, the jury is hopelessly deadlocked on that charge of a lesser included offense. Is that correct?
Yes, it is.
So you were unable to reach a unanimous decision as to assault in the first degree reckless in violation of Connecticut General Statutes 53A, 59A3 as a lesser included offense under count 3. Is that correct?
Yes, Your Honor.
Thank you. Madam Clerk, please proceed to count 4.
Count 4 of the substitute information charges the defendant with the crime of assault in the second degree intentional in violation of section 53A-60, paren A, paren 2 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, Court Exhibit 10, the note that was forwarded to the court indicates that at count 4 as to assault in the second degree reckless. After lengthy deliberations, the jury was hopelessly deadlocked on the above charge. Is that correct?
That's correct.
All right, so is it correct that the jury was unable to reach a unanimous decision
Jamie
as
is wrong,
to
yes.
assault the second degree reckless in violation of Connecticut General Statutes, section 53A-60A3 at count 4?
Yes, Your Honor.
Thank you. Madam Clerk, you may proceed.
Your Honor, may the verdict be accepted and recorded?
Yes, the verdict shall be accepted and recorded.
Ladies and gentlemen of the jury, listen to your verdict as it is accepted and recorded. As to the first count of the substitute information charging the defendant with the crime of murder in violation of section 53A-54A, paren A of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to count 1 of the substitute information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of section 53A-55, paren A, paren 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the second count of the substitute information charging the defendant with the crime of assault in the first degree intentional in violation of Section 53A-59, paren A, paren 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the third count of the substitute information, charging the defendant with the crime of assault in the first degree intentional in violation of Section 53A-59, paren A, paren 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the fourth count of the substitute information, charging the defendant with the crime of assault in the second degree intentional in violation of Section 53A-60, paren A, paren 2 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
Ladies and gentlemen of the jury, please rise. You heard your verdict
Wow.
as it was accepted and recorded. You heard your verdict being read back as to each of the four counts. Is that your verdict? So say you all.
Yes.
Thank you. You may be seated.
I'll run it down when we're done here. Let's just hear when what the judge says.
Anything from counsel at this point?
No, Your Honor.
No, Your Honor, may we be seated?
I'm sorry?
May we be seated?
Yes, you may be seated. Thank you. All right, on no request by counsel, the court is not going to hold the jury. So I won't have the claim. All right, ladies and gentlemen of the jury, I'd like to address you. Take a moment. Your verdict has now been recorded. It's been accepted by the court. The court will deal with the outstanding remaining charges once I discharge you, but I want to say a few words to you before I do that. Your oath that you've been obligated to keep during this time, you've been obligated to stay silent, not discuss this case. I am now relieving you of the duty of your oath, so you are released from your oath. It is, of course, up to you to decide whether or not you wish to discuss this case with anyone or your role as a juror with anyone. You certainly
If
have
anyone
no
wanna come
obligation
on,
to do
Call
so.
me.
And please be aware that any comments that
Right,
you
Marissa.
shall make may become the cause for further proceedings concerning the verdict. I would like to take this time to recognize you and thank you for your very important service, serving as a juror, especially on a lengthy trial such as this. This takes you away from very important other aspects of your life. So I want to thank you for the time commitment that you gave to this case. I know that we originally asked you for a commitment through July 1st, and you have graciously given us your time for a rather extended period beyond that July 1st date.
Stop popping your
Inevitably,
head.
a decision by a jury will gratify one party and disappoint another. It's a very difficult job that you have. It's a difficult job for a juror to be asked to make a decision, such as important ones like this. And I understand, and so does everyone involved, that the decision that you made here today is not an easy one. These are decisions, however, that are extremely important to our society, as well as the individual defendant. We all recognize that it's not an easy one, and we thank you for taking the time to reach the decision that you did reach here today. We're very grateful to you for performing that very important assignment. I want to also thank you for your careful and diligent attention to these proceedings. I know that sometimes it's very difficult to get through evidence. It's not always as exciting as it's portrayed on TV or in the news. You as jurors have to stay alert and awake and dedicated to every moment of evidence that's presented before you. And I constantly remained vigilant of all of you and your attention. And I want to thank you for providing us the attention.
Also
that
frolic
you
for the
did.
man who hasn't
So at this
alive.
point, I want to let you know that you are discharged again from your oath. You are allowed to leave. However, there are
I will tell you in
documents that
5
we do
seconds.
need to provide to you, and I would also like an opportunity with you to give you those documents with the clerk. I would appreciate it if you would stay back here at the courthouse for a little bit. There are some matters I do need to tend to on the record, but if you would just give us a little bit more of your time just so that I can get you those documents, I would appreciate it. Although you are under no obligation to do that. So that's an individual choice. You will be escorted out by the marshal. I will ask that you remain in the room for a little while so we can clear halls and I can clear the courtroom and then hopefully get a chance to speak with you. Thank you.
Wow, that's so long. Ooh, he got lucky.
Let's hear what they're saying.
The jury's leaving.
Attorney Smith, at the end of evidence, at the close of evidence, you moved for a judgment of acquittal on the 4 charged offenses, paying most attention to the murder charge at count 1. The defendant has since been acquitted as to all of those charged offenses in the substitute information. What is your position relative to the motion for judgment of acquittal on those 4 offenses?
Withdrawn, Your Honor.
So the court's going to name that for the record. With respect to count 1, manslaughter in the first degree reckless, Connecticut General Statutes, Section 53A, 55A3, count 2 and 3, assault in the first degree reckless, Connecticut General Statutes, Section 53A, 59A3, and count 4, assault in the second degree reckless, Connecticut General Statutes, Section 60A3. After the jury's inability to reach a unanimous verdict, the court would like to memorialize on the record the following. On day 1 of the jury having the case, after about 2 hours of deliberations, the jury sent a note stating that it was hopelessly deadlocked on the murder at count 1. The court, upon agreement of counsel, instructed the jury to continue deliberating, instructing the jury to review the evidence, discuss and consider the opinions of other jurors, to explain views and listen to the views of others, including the majority, to listen to what the minority had to say, and the minority to listen to what the majority had to say. Subsequently, after a total of about 5 hours of deliberations having passed, the jury sent a second note to the court indicating that the jury was deadlocked on murder at count 1, not guilty of first-degree assault intentional, deadlocked on first-degree assault reckless at count 2, with the same indication for count 3 on the same charges, and not guilty second-degree assault intentional, deadlocked second-degree assault reckless at count 4. Once again, upon agreement of counsel, the note was disclosed to counsel. Obviously, it was reviewed, it was discussed, and I directed jurors to continue deliberating, instructing the jurors to review the evidence, see if any evidence was overlooked or misunderstood, to explain the views and listen to the views of all other jurors. The jury continued their deliberations into the 3rd day. And now, once again, on this 3rd day, after more than 11 and a half hours of deliberations, the court received a note from the jury, now Court Exhibit 10,
He can be
indicating
retried
a
on the lesser
partial
included.
verdict. And that as to the other charges, the lesser included offenses, that after lengthy deliberations, the jury was hopelessly deadlocked. Due to the jury's inability to reach a unanimous verdict, even after extended deliberations, as to manslaughter in the first degree reckless, Connecticut General Statutes 53A, 55A3 as a lesser included offense at count 1, assault in the first degree reckless, Connecticut General Statutes 53A, 59A3 as a lesser included offense at counts 2 and 3, and assault in the second degree reckless, Connecticut General Statutes Section 53A, 60A3. The court, in accordance with the Connecticut Practice Book, Section 4245, and with no objection by counsel. Counsel, do either of you want to object? I know before you indicated you didn't. Objecting to a mistrial?
No.
No, Your Honor.
All right. Hereby finds it necessary to declare a mistrial as to those offenses and all other lesser included offenses charged to the jury under counts 2 and 3, to which a verdict was not returned. The court does not take the ordering of a mistrial lightly. The court is not ordering a mistrial simply for the sake of ordering a mistrial as a matter of convenience. Rather, the court, based on the history of deliberations as cited herein and the notes provided by the jury, finds that the circumstances make it impossible at this point to reach a verdict fairly as to all parties, and as such, with a finding of manifest necessity in accordance with our rules, does enter the order of the mistrial. I'd also like to take a moment to address everyone. I first would like to address counsel and thank them for their courtesies to the court and to each other during the course of this trial. Also to the family members, all of them, the spectators that have been present in this courtroom every single day. I want to thank you for heeding the court's expectations as to courtroom decorum. I know that this was an extremely emotional trial, and I appreciate the conduct that was displayed continuously throughout this process. Once again, I understand that a jury's verdict will never fully satisfy one side or the other. Not everyone will walk out of here satisfied today. And I apologize for that, but this is the process that we have, and the court believes it to be a fair process. I also want to indicate that my appreciation to courtroom decorum extends to every single member of the media. I think you've portrayed this matter as fairly as possible in the news, and I think that your courtroom decorum here in following all the rules that were placed on the media by way of court order have been met with professionalism in terms of your business and your duty to your job. So I want to thank you for that. At this time, I'd ask counsel if there are any other matters that the court should take up.
Nothing from the state at this time, Your Honor.
Not from the defense, Your Honor.
Lastly, I would like to address Mr. Valle. Mr. Valle, you too have shown respect to the process in terms of your decorum and your behavior and conduct here in the courtroom. You have been acquitted of the 4 charges that were held against you and stated in the substitute information. So at this point in time, I wish you the best of luck moving forward.
Thank you.
Counsel, thank you. Thank you to everyone. Court stands adjourned.
All rise, court's adjourned.
Oh, boy.
I don't understand the last thing she said because she declared mistrial, but not with prejudice on 2 and 3.
What were
So
2 and 3?
2 and 3 was aggravated assault.
Okay.
So he has been found not guilty in murder on manslaughter, but in every case they were hung on the lesser included. The lesser included are not intentional, the Sarah Boone defense. And but only in 2 and 3. She didn't say mistrial on 1 and 4 in the lesser included. That's where I'm wondering, because as I see it, I can't read Jess's post. She's I blocked her. I don't know where she is. So if he was not guilty on the main charges, they may be prevented from bringing a retrial on the lesser charges if the elements of the lesser charges are the same as the main, which they usually are. But she only said that she declared mistrial on the aggravated assault. So this seems
well,
like he's free.
Yeah, because they were definitely not guilty on murder, manslaughter, basically all the main ones. All the ones that matter.
Yeah. He can't be tried again for reckless murder. He can't be tried again. I don't know why he couldn't be charged for the second degree assault. But if she declares mistrial on the 2, that's...
But
She
she
might
didn't say. Yeah.
I'll go into Discord. You probably wrote it in there, so no, you didn't. It's way easier when you write it in Discord instead of I have to go back 50 posts.
So I will say I was wrong then, because I totally thought the one holdout was not guilty. But I think it was the other way around.
No, I think they all agreed that he wasn't guilty in intentionally doing it.
Well, they were hung on everything for the 2 days. And
No,
then they came back.
she just read it to us that they were not hung on the intentionality. They were hung on...
No, initially. Initially.
None of it. That's what she read. After 1.5 hours, they came back and said, nope, we can't agree on the lesser included. So someone has been not guilty all the way, or some of them have been not guilty all the way, but they have all agreed he was not guilty in intentionally hurting these people, is how I understand what she read. So this is actually where an OUI could have probably sped this along, like in Karen Reed, that they all agreed that he was overcharged. Some of them wanted to give him some punishment, and if there had been some kind of snuggly little, it's a nothing charge, they would have ended on that one. No one knows what the 11-1 was, and as she read it, they have been in agreement since day one on the major charges, not the lesser included, but the big charges. So that's, I see it as someone have said, nope, absolutely not guilty. And some people have said, well, he's a little guilty. That's how I understand her.
Oh, well, when I listened to the note the first time, she said they were hung. They were 11-1 on the first charge, and she told them to go back and they need to start debating.
But the
on
first
the other
charge
charges
is not just murder. The first charge is murder 1, manslaughter, and all the lesser included. So they probably went in there, all of them, and said, this is way too shady. All of this is absolutely out the window. He's not intentionally. He didn't do it intentionally. The Sarah Boone defense.
Well, that's
and
what
then
I mean.
they said,
that's what I said. I think they were not guilty, and one was guilty.
But you said one person was not guilty on charge 1, but I think all of them agreed that all of the intentional that he went to the party with the stabulator to hurt someone. I think that they all agreed instantly that's not it. And then they have been fighting, can we give him something? Because some people have been sitting there saying, well, we need to punish him. A kid did die. And other people have said, nope, this is crazy. If he had gotten reckless murder, that's a 10-year sentence. So he should be lucky that they couldn't agree. Is there a verdict form? Nope.
Yeah. Well, I was just saying the first time around, it was just they were hung on the first charge. And then she told them to go back and debate the other ones. And then when they came back the end of the day, she said they were hung on everything. And I was like, oh, good God. And she still said it was 11-1. And initially I was thinking, oh, we have one not guilty holdout. But I'm thinking that it was the opposite now, hearing that they came back like not guilty on everything.
No, I think they were all in agreement. There was no intentionality, and then they were fighting if he should have something. This is how I understand it. They were all in agreement. He wasn't a murderer, and he didn't commit manslaughter. And then what they have been hung on the entire time are the lesser included. That's how I understand what was said, because she said when they came back the first day, they had the same position on charge 1. That's why she didn't want to send it back.
After I saw his testimony, I was not guilty. So I
was manslaughter because he did kill a man, and he didn't have to go back to them.
I believed what he was saying, in my opinion.
Well, you could see what he said wasn't right. So, but I think the thing that really 15 to 2. Let's just give it the middle number. Everyone wanted to fight. He had been punched around, and he just slashed around him. I think that's why they said, no, he never, ever intended to kill anyone. And the assaults were probably flailing with a knife. That's what I think we are in. This kid should never play the lottery because he has no luck left. He could have ended up doing a lot of time. What was the charges? Murder, aggravated assault, and the second-degree assault. Let's see. I don't want to. I just want to have the verdicts. Don't they have the verdicts? Bum, 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 bum.
I think there was like 30 people there, like all together, but I mean, there wasn't 30 people on him at one time.
Well, we saw the fight. That was way over hyped. What?
I mean, there was a group of them for sure.
The jury has reached a partial verdict on the trial and found him not guilty of murder, manslaughter, or assault. The judge declared a mistrial on the charges that the jury could not make a decision on, but they did make a decision, just not on the lesser included. So I'm still confused why she said 2 and 3.
Yeah.
Jess, I do know there's first degree and second degree assault. I'm talking to her because he's in Discord and I don't have time to write. My understanding is they are not guilty on all intentional charges. Then why are only the first degree assaults mistrials? That's the thing I don't understand. Why isn't the second degree assault mistrial? Why isn't the murder a mistrial? They agreed on everything, intentionally wasn't there. Yes, I understand. I think she's writing and I forget she's 10 seconds behind.
I mean, you can always just play the reading of the verdict again.
Yeah, but I still don't understand why the first degree assault is mistrials and the second degree assault and the murder is not mistrial. She only said in charge 2 and 3, which is first degree assault, but
well, the murder was not guilty. Which murder would?
But he was also not guilty in first degree assault, and they were hung on the lesser included. He was not guilty in all the primary charges.
Mm-hmm.
But let's listen to it again.
Okay.
Second degree intentional in violation of section 53A.
Reckless in violation of Connecticut.
Find the defendant guilty.
Must agree to lesser included.
Intentional.
And I'm going to boost the audio when she talks.
Intentional act. Mr. Foreperson, in the case of State of Connecticut versus Raul Valle, has the jury agreed upon a unanimous verdict as to murder at count 1, manslaughter in the first degree intentional at count 1, assault in the first degree intentional at counts 2 and 3, and assault in the second degree intentional at count 4?
Yes, we have.
Will the defendant, Raul Valle, please rise and face the jury? Will the defendant, Raul Valle, please rise and face the jury? Do you find the defendant guilty or not guilty?
Not guilty.
We have to go through the docket number 8.
Oh, it's not on here. Sorry. In docket number AAN CR 22-0189-418T, count 1 of the substitute information charges the defendant, Raul Valle, with the crime of murder in violation of section 53A-54A paren A of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
As to count 1 of the substitute information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of section 53A-55 paren A paren 1 of the Connecticut General Statutes, do you find the defendant guilty or not guilty?
Not guilty.
Okay, Madam Clerk, please pause. All right, I'm going to direct the court's inquiry to the foreperson at this time. Mr. Foreperson, your note indicate, and that's Exhibit 10, Court Exhibit 10, your note indicated that the jury, after lengthy deliberations, was hopelessly deadlocked on manslaughter in the first degree reckless in violation of Connecticut General Statutes 53A, 55A3 as a lesser included offense at count 1. Is that correct?
Yes, Your Honor.
All right, so you were unable to reach a unanimous verdict as to that particular charge, is that correct?
That's correct.
Madam Clerk, please continue on with count 2.
Count 2 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, Court Exhibit 10, again, the note that was sent to the court, provided to the court and marked, indicates to the court that after lengthy deliberations, the jury is hopelessly deadlocked
You'll get the same for every count.
on the charge of assault in the first degree, reckless, in violation of 53A-59A3 as a lesser included offense at count 2. Is that correct?
That's correct.
All right, so you were unable to reach a unanimous verdict regarding that particular charge as a lesser included offense. That is correct.
That's correct, Your Honor.
Thank you. Madam Clerk, please continue on to count 3.
Count 3 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Again, Mr. Foreperson, Exhibit 10, Court Exhibit 10, your note to the court indicates that with respect to assault in the first degree, reckless under count 3, after lengthy deliberations, the jury is hopelessly deadlocked on that charge of a lesser.
They didn't believe it was self-defense because that was a charge they would have to go after they found him guilty or not guilty. Then they would have to say, but was he excused because of self-defense? So they haven't decided if it was self-defense.
The defense, is that correct?
Yes, it is.
So you were unable to reach a unanimous decision as to assault in the first degree, reckless in violation of Connecticut General Statutes 53A, 59A3 as a lesser included offense under count 3. Is that correct?
Yes, Your Honor.
Thank you. Madam Clerk, please proceed to count 4.
Count 4 of the substitute information charges the defendant with the crime of assault in the second degree intentional in violation of section 53A-60, paren A, paren 2 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, Court
No, I wasn't in that room, but I just heard the verdict. The verdict would be guilty, but acted in self-defense, because the self-defense was instructed to them. If they found him guilty, they would have to evaluate if he did it in self-defense.
Exhibit 10, the note that was forwarded to the court, indicates that at count 4, as to assault in the second degree, reckless, after lengthy deliberations, the jury was hopelessly deadlocked on the above charge. Is that correct?
That's correct.
All right, so is it correct that the jury was unable to reach a unanimous decision as to assault in the second degree, reckless in violation of Connecticut General Statutes, section 53A-60A3 at count 4?
Yes, Your Honor.
Thank you. Madam Clerk, you may proceed.
Your Honor, may the verdict be accepted and recorded?
Yes, the verdict shall be accepted and recorded.
Ladies and gentlemen of the jury, listen to your verdict as it is accepted and recorded. As to the first count of the substitute information charging the defendant with the crime of murder in violation of section 53A.
No, but the law matters when they give over the. You can't be guilty and act. You can't be innocent and act in self-defense. It's that simple. A self-defense plea is a guilty plea. They were ordered to examine if they found him guilty if it wasn't self-defense. So they didn't find him guilty in any intentionality in this. So that if there's no intentionality, it's not acting in self-defense.
54A, paren A of the Connecticut General Statutes You say the defendant is not guilty. Is that your verdict?
Yes.
As to count one of the substitute information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of section 53A-55, paren 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the second count of the substitute information charging the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the third count of the substitute information charging the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the fourth count of the substitute information charging the defendant with the crime of assault in the second degree intentional in violation of section 53A-60, paren 2 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
Ladies and gentlemen, the jury, please rise. You heard your verdict.
Yeah, the self-defense checkbox is under yes for guilty. So when they said he's not guilty on any intentionality, that takes away the self-defense. You can sit and say that's why why they went there, but that's not what the court found. They found him not guilty. And yes, I always say the law has nothing to do in the jury room, but they came back and said, we don't believe he intended to do any of these 4 charges. But I'm going to try and find the place where she declares mistrial, because as I understand it, she only declares mistrial on 2 and 3. And if it's something magical, you can't do it with a murder charge that he's free to go because you can't get the lesser included, which I don't think you should. Why the hell? No, they read the exact same, Jess, that they were hung on the not intentional.
All of those in 583 record. With respect to count 1, manslaughter in the first degree reckless, Connecticut General Statutes, section 53A, 55A3, count 2 and 3, assault in the first degree reckless, Connecticut General Statutes, section 53A, 59A3, and count 4, assault in the second degree reckless, Connecticut General Statutes, section 60A3. After the jury's inability to reach a unanimous verdict, the court would like to memorialize on the record the following. On day 1 of the jury having the case, after about 2 hours of deliberations, the jury sent a note stating that it was hopelessly deadlocked on the murder at count 1. The court, upon agreement of counsel, instructed the jury to continue deliberating, instructing the jury to review the evidence, discuss and consider the opinions of other jurors, to explain views and listen to the views of others, including the majority, to listen to what the minority had to say after note guilty of first degree assault intentional, deadlocked on murder at count 1, not guilty of first degree assault intentional, deadlocked on first degree assault reckless at count 2, with the same indication for count 3 on the same second degree assault reckless. Upon agreement of counsel, the note was described to review the evidence, see if any to the third day, 11 and a half hours of deliberations. The court received a note from the jury, now Court Exhibit 10, indicating a partial verdict, and that as to the other charges, the lesser included offenses, that after lengthy deliberations, the jury was hopelessly deadlocked. Due to the jury's inability to reach a unanimous verdict, even after extended deliberations, as to manslaughter in the first degree reckless, Connecticut General Statutes 53A, 55A3 as a lesser included offense at count 1, assault in the first degree reckless, Connecticut General Statutes 53A, 59A3 as a lesser included offense at counts 2 and 3, and assault in the second degree reckless, Connecticut General Statutes section 53A, 60A3. the court, in accordance with the Connecticut Practice Book, Section 4245, and with no objection by counsel. Counsel, do either of you want to object? I know before you indicated you didn't, objecting to a mistrial.
No.
No, Your Honor.
All right. Hereby finds it necessary to declare a mistrial as to those offenses and all other lesser included offenses charged to the jury under counts 2 and 3, to which a verdict was not returned. The court does not take the ordering of a mistrial lightly. The court is not ordering a mistrial simply for the sake of ordering a mistrial as a matter of convenience. Rather, the court, based on the history of deliberations as cited herein and the notes provided by the jury, finds that the circumstances make it impossible at this point to reach a verdict fairly as to all parties, and as such, with a finding of manifest necessity in accordance with our rules, does enter the order of the mistrial. I'd also like to take a moment to address everyone. I first would like to address counsel and thank them for their courtesies to
It's got to be the way it's charged that she could only do a mistrial on 2 and 3. Well, but they still can't. They found him not guilty, so they can't charge him again with intentional. They can't charge him with first-degree assault, can they?
Yeah.
Because he can't be retried for the murder. He can't be retried for the manslaughter. He can't be retried for the second-degree assault. Then why can he get retried for? Because there's the same finding in every charge against him.
Well, they didn't, the ones that got thrown out were the reckless ones, right? So they can go back for
No.
reckless.
All of them have a reckless. You have reckless murder. You have reckless assault. You have reckless assault in the second degree as well.
Yeah.
Every charge was found not guilty in intent. So why is it only in the first degree? Is it because they can come back and charge them with second degree? Wouldn't that be a double jeopardy that they just, well, we just downvote you? Then why can't they just go and say reckless manslaughter? That's
Well,
no. She only called in charge 2 and 3. He was not guilty on the main charge and deadlock on the lessers. Then they can't bring it again for the lessers because that would have similar elements. Then why does she declare a mistrial on the 2 first-degree assaults? That's the thing I don't understand. Why isn't he just thrown out because they couldn't agree on the lesser included? So they could. That's the thing I don't understand. Can they try him again for the lesser included?
I mean, it seems like they can, but
Yeah, but only in 2 and 3. She could have said made a mistake, but then she should come back and correct the record. The lesser included, as long as manslaughter is off the table, it'll go down to potentially not a lot. As long as there's yes, they can. Yeah.
what?
Yeah, everyone knows anything. No, she didn't call a mistrial. She said on count 2 and 3. We just heard it. She said on counts 2 and 3, I declare a mistrial.
Yes.
She doesn't say on all counts.
Yeah, not on all counts. He was not guilty on the main ones, so he's
Yeah.
never going to be tried for those again.
And that's the thing, because she didn't say mistrial with a prejudice. So can they convert the first-degree assault to second-degree assault and try him again?
To declare a mistrial as to those offenses and all other lesser included offenses charged to the jury under counts 2 and 3, to which
She only says 2 and 3.
I'm seeing what Jess is saying, and that's like my thought process too.
That's where I am too, but then why does she declare a mistrial on 2 counts? That's just the thing that I don't understand. Because if it's a mistrial without prejudice, they can try the first-degree assaults again. But if they can try the first-degree assaults, why can't they try the second-degree assault? That makes no sense. I can understand why they can't try the murder again. But if they can try the first degree, they can try the second degree. That was first degree assault, which is how long does
Yeah,
that?
that's what I'm thinking all the time.
Whip, whip.
Because if the entirety of the elements and the lessers are the same as the top charges, then they are dead. And that's what I would think too.
In Connecticut, first-degree assault, as defined by CGS 53A59, is a Class B felony. Conviction can land you in prison for up to 20 years and a fine of up to $15,000. And there's a mandatory minimum sentence that can apply depending on circumstances, which is no, that doesn't apply. I just never heard. Well, we never had a partial verdict as well.
No, we haven't. So it's a little weird.
It's absolutely sad for Jimmy's family, and I still believe I would have voted for manslaughter because he had the possibility to remove himself, and his friend was not in danger when he did it. The job charges have the same plus more. That is what lesser included means. So it's like, okay, they didn't prove all of the main. Did they get these few then? So then they can come back for the lesser. Well, then they can come back for reckless murder as well. And she didn't say that. She says he's free to go.
the verdict was not returned. During it possible at this to organizations as to courtroom process fully satisfy one side in a process, and to courtroom decorum extent as possible in the news, on the media, in terms of counts. If there are any other. Lastly, I would like to address Mr. Valle. Mr. Valle, you too have shown respect to the process in terms of your decorum and your behavior and conduct here in the courtroom. You have been acquitted of the 4 charges that were held against you and stated in the substitute information. So at this point in time, I wish you the best of luck moving forward.
Thank you.
Counsel, thank you. Thank you to everyone. Court stands adjourned.
All rise, court's adjourned.
Blake, det kan man, fordi at det er indbygget i et mord. Der er der, at det kan være uagtsom manddrab, eller bare manddrab. Men jeg forstår bare ikke, hvorfor med nummer 2 og 3, som er grov vold. I Danmark har vi også, okay, grov vold kan nedjusteres til almindelig vold. Men det giver bare ingen mening, at hun så kun siger mistrial på de 2, i stedet for, at det er hele pakken. Det er det, jeg ikke forstår, men hey, jeg er bare en dum bager. Jeg fatter ikke noget. Right, Jamie?
Yeah, that sounds good.
How I feel about this verdict, I would have found him guilty in manslaughter. Maybe reckless manslaughter. I don't think he had any intention to do it, but he did bring a knife to a fist fight. and he stepped back into the. I think the 3 assault charges was self-defense. They were on the ground, everyone was punching everyone, and he flailed around. But stepping back in and stabbing Jimmy, I would have gone for probably. I would be one fighting for manslaughter on that charge, because he did use the knife and he could have gotten away. But that's how I feel. And I've been there the entire time since I saw the video, because his body was not in the mix. He wasn't running in and stabbing someone who was beating his body. To me, that's manslaughter. But hey, I'm a tough ass, so that's how I see it. You don't have the right to unalive someone if you can just walk away and they are not attacking you. That's not self-defense. I know a lot of people think, there's a lot of shenanigans going on because there was a lot of immunity deals, which I also believe. I believe there should have been more charges brought against more people. But I also know in America, the prosecution will make a deal to try and get just one conviction. And I don't like that. I think it's a disgrace that the 2 guys who instigated the fight got off scot-free just to try and pin it on this kid. And I think he's overcharged. The severity of the crime makes him mandatory to be charged as an adult. But in my opinion, he was overcharged. Manslaughter is the maximum I could see. Offering him a plea deal on 40 years, absolutely retarded. But the state believed they could just roll over him. A 16-year-old kid at the time, 19, maybe 20 now, giving him 40 years. You can just give him life instead. So, of course, he wouldn't take that plea deal. A reasonable sentence in my mind, probably 10 years, I would have thought would be reasonable for what he did. But that's me, and I'm tough. But I still believe that he did something he shouldn't have done, and I don't think it was okay that he did it. Again, had it happened while they were in the scrum, I would have gone with defense of others, defense of himself. But because his friend was away and he stepped towards the danger, I didn't like that.
I wasn't that guilty.
We don't know who was anywhere. Were
No,
anywhere.
I said I was.
Oh, I was answering Nonya that says, anyone know if the family? I said, no one knows.
No.
Der er nogle gange, når vi ser de her retssager, så forstår vi det ikke, fordi vi har ikke de dele bygget ind i det danske system. Enten der bliver du dømt skyldig i mord, eller også så bliver du ikke dømt skyldig i mord. Her der og det, jeg synes, det er sådan noget pjat, for enten der må du dømme den med det, du anklager dem for, eller også så må du lade være med at dømme den. What I said was, we don't know this system in Denmark because we don't have all these lesser includeds built in. Either you charge them with what you believe they're guilty of, and you win or lose on that. You don't do all of these lesser included. So there's all these get out of jail free cards for the jury to just, well, he didn't intend to murder him, but he did do something wrong. I think it's a problem. In the Karen Reed case, it saved us from a hung jury that they put the OUI in there. But with capital offenses, you should only charge them with what you believe you can prove. And something as severely as murder, you shouldn't be able to say, well, it could also be manslaughter. Well, it could be unintentional. Either you believe in your case and you ride or die, or you don't believe in your case and you don't charge. If you don't believe enough that you have enough power to hit a murder charge, you go with manslaughter. I think it's a big problem, and we have seen it in a lot of cases that people get massively overcharged. Most of the time because people will take a plea deal, because people don't have money to put on a good defense. Raul didn't put on a good defense. I thought his defense attorney was horrible. He was good in arguing with the judge in the motions, pretty decent closing, but I thought he was really bad at cross-examining witnesses. So that's just my take. He is lucky that the jury is not your everyday jury. Yeah, exactly. If you want all of these get out of jail free cards put into your verdict, you have overcharged. Not guilty on everything intentional, hung on everything not intentional.
Ja.
Det bliver noget af en omgang, fordi der er forskel på retssystemerne. Blake is asking if I can tell you how our rights are in Denmark compared to the US, but they are two different court systems, so it's way different rights that we have. We have that right. We can ask for any attorney, and as long as they don't have any other cases, they will be provided for us, and the state will pay for them while our defense goes on, and then they will get the money from us later. I think that's a very important right we have. So if you live in California, you can just say, I want Alan Jackson. And then if Alan Jackson doesn't have any other cases, he must provide a defense for you. And then it's between you and the state to pay back, and he'll get a rate. They don't get massive amounts of money. They'll get a rate per hour they defend you, and then the state pays them, so they will get paid, and then the state will then take the money out of your. If you have money, you'll of course pay yourself, but if you don't have money, well, they will make a pay-as-you-can man plan, where they'll take it out of whatever income you have until you're paid it back to the state. I think that's a good way to prevent this poor plea, can we call it that, where people who can't afford a lawyer just takes a plea deal because they don't want to be hung with a public defender who has 40,000 cases running and can't provide a decent defense. And I think that's one of the biggest differences and a very important difference we have in our system. Kevin Smith is a highly regarded defense attorney in Connecticut. These were tough witnesses with constantly involving stories, even during the course of their time on the stand. He is, I believe, not a very highly regarded defense attorney. He worked for a company that got in trouble. His former boss or partner lost the right to work as an attorney for 6 months. We have he was removed from the case in what's the case, Jamie?
I don't know.
The Huli Wuli one that people have been mentioning all the time.
I don't know what people are talking about.
Well, the case everyone always told me, oh, don't you remember him from the 1A1? And then we found out he didn't represent them in court because he had been removed before that. I didn't think he did really good in this case. I believe that it's more on the jury than it's on the defense attorney. If they have constantly changing stories, you point it out. That's your job as a defense attorney. Sow doubt about the testimony. And he didn't do that. He never really got into. If you watch the Karen Reed trial, they did it a lot where they said, didn't you say this in this and this interview? And he did it a few times, but that's not good.
Rainy Day saying something about this person. Is that who you're talking about?
Yeah, the 40s Doulos case.
She said he wasn't removed from that case. The guy offed himself.
Oh, well. Imagine having such a bad lawyer, you're going to say. Oh.
Oh my God.
Jamie, you stop saying stuff like that. I think the mute jury got it wrong, but didn't he also get recorded making racial slurs or something? No. That's a big misunderstanding. I've seen a few people have said, oh, well, he was guilty because he was racist. No, he wasn't. and he didn't go back to the kids. This is the big difference between the Mew case and this case. Mew actually went away from the initial contact and was attacked by the kids, put underwater a few times. His biggest problem was he lied to the police when they asked him on the parking lot after, said, "Hey, do you know anything about this?" He said, "Nope, don't know anything."
Yeah.
I think
That
that's
was-
what done him in, because I think he had more of a self-defense claim than this kid had, because he came up from under the water and just did this, while he had been punched twice, been dunked underwater 1 or 2 times, and they were grabbing for him. The kid he ends up killing actually was in motion towards him with his arms outstretched. So that's way more self-defense than this case. And that state doesn't have a duty to retreat either. So I actually think he's more innocent than Raul Valle. But he lied and he tried to hide, and that'll be a problem.
But the jury, the guy that did the interview after that case, his actual saying was that he said that Nicholas could have walked away. And
Yeah.
that was what got me. And I was like, these guys are crazy. What are they thinking? Like, he did walk away. And then those girls came up and were yelling at him, and he stopped to say something to them. And then the boys came back.
Yeah, and that other group that came down and attacked him, that had nothing to do with anything, and he was just standing in the middle of the river when they re-engaged with him. So they were the ones who re-engaged with him. Well, he could just have walked down river. They could just have sailed right on by. But for the culture, and that lost them a friend.
Yeah, that sucks.
Only now they put on harsher sentence in Sweden for unaliving. My friends, then 17, was unalived by one stab by a 15-year-old, and the murder got 1 year in juvenile camp. Yeah, but we have a way different system. I had a murder case with a guy who unalived his girlfriend by beating her. And we're not talking about, hey, one punch, it was an unlucky punch and it just hit and everything. No, we're talking about a doctor who was in the ER when she came in, who sat in court crying. We're talking about some of the worst pictures, and I used to watch horror movies. Some of the worst pictures I have ever had to look at. We had testimony from the medical investigator medical examiner, who said, I have never seen so much damage done to a body where there's no car involved. He got 12 years in prison. But that's because we have a way different view on punishment, because this guy had also just been released from prison like 2 months before. Not for anything like this. I think it was drug related or something, his other charges. But that makes a bit of an impact when a doctor sits in court crying because of the injuries were so horrific. But we have a different system. And again, I have no opinions on sentencing in the Danish system, as I am one of the one who sentence people. Until one child dies for nonsense, no one will understand. What if it was your child who was stabbed? Well, it wasn't. Will I ever understand? Hopefully not. Hopefully never.
But you have to look at all the circumstances as a whole.
But again, you are not out to do vengeance. You are out to do justice. And you might think this is wrong because a kid died. But the justice system is still built in what you have to reach beyond a reasonable doubt to find someone guilty. And it clearly shows that the jury didn't find this was intentional. Then you can say, well, as I didn't think that he had a right to stab him in self-defense. I think he re-engaged with the fight, but I also have to agree with the jury because they found him not guilty in those charges. And you don't have to yell at me. I'm not on the jury. And you don't have to, you're not going to change anyone's mind in chat that, well, this happened or that happened. We all have a right to our opinions. Do I think that it's a waste of human life every time someone like this dies on a stupid accident or because someone wants to show them he has bigger balls than the other ones? Yeah, I think it's absolutely the worst thing in the world. Have I been in a ton of fights when I was the same age? Yeah. Have I done things that I'm not proud of at that age? Yeah. But again, you still have to convince the jury beyond a reasonable doubt that this was a guy who wanted to take a life.
Because
You
that's what they were
can
saying.
unintentionally take a life. And this is what I believe happened in this case. I think he just wanted to show I have a bigger dick than you. And that sadly ended in a young man not being here anymore. I think he should have had some punishment. I would have said manslaughter, reckless manslaughter. That's where my dice would have landed. But we all look at the evidence differently. Some people are just not guilty unless they hear him yell for the culture and then go steepity stab. I think there was enough to say that was manslaughter. I know roughly half my chat said nope, I couldn't go there. But again, I'm Teflon Soul. I don't care. I think that they convinced me enough for manslaughter. And every day, juries all over America will have to sit and decide in cases that they hopefully never, ever will experience themselves.
Yeah.
In Florida, I think right now there's a wife on trial for shooting her husband, maybe in cahoots with her lover. There's another trial where I think he is mentally challenged. Sadly, it's on Court TV's own website, so I can't show it. Who unalived a girl who was fond of sitting on a swing in a park. Do I hope it happens to anyone? No. Do I hope that I ever get in a fight again? No. Do I know anything about dealing drugs? No. But I'm a jury in all of these cases as well. And that's what you have the jury system for. Not so one-on-one you know what happened, but to find justice. This is not a revenge. That's why we have the justice system. It's to find the right punishment. It's not to get revenge. Because if we just wanted revenge, it's outside of the saloon at high noon. And then God may decide who is right. That's not how the justice system works. So just because you're angry and one kid is dead, that means someone else should pay for it. I agree. He should have paid. But the jury didn't see it my way. They aligned with Jamie and Sue, as they always do.
I thought,
Them's the apples.
again, like you said, with these immunity deals and stuff like that, a lot of shady stories. I couldn't see it. And surprisingly, even with the Connecticut being you have to retreat state, I was a little surprised. So, and you are right, Sue. Revenge has no place in the justice system.
No, we are the cold-hearted bastards who sit and listen and look at people who cry, and then we'll have to go back. Just let me finish this. I'm just trying to figure something out with this.
Keep on. I mean, everybody's going to have their opinion on this.
Of course they
There's
have.
always, every time we have a self-defense case or some type of self-defense case, there's always going to be people that are like, they don't believe that it should have
No,
happened at all. And some people
right
do.
now I
And
bet
it's,
you there's 95% on Law and Crime who says, he better get out of town before the family gets him. I hope the
yeah.
family don't have those crazy ideas. Because again, we have the justice system to figure out what's right and wrong. Do I agree every time? Absolutely not. I don't agree in this one. Does that mean that I can't tell you what happened? No, of course I can. And one of the things you will learn if you're ever on a jury is that you will have to sit and look at it objectively. I had a case with a guy who was charged with 8 counts of rape. 2 of them he kidnapped for a week. 1 of them he threatened to throw out a window. He even held her outside of a window. And I had to sit and listen to these young women. Did I want to punish him really, really hard? Yeah. But we had to go back and sit and say, well, can we prove it's rape? Because there's rules for when it's rape. Because if you don't say no and you don't show no, then how could he know it's no? And back then we have had consent laws put in now. Back then he had to physically restrain the victim or verbally intimidate them, I think was the rules. It's been a while. But yeah, we were sitting and going through every line of testimony. Oh, she said he pulled the car door shut. Okay, he restrained her. Because we really, really didn't like this guy, which we shouldn't have in the room with us. And we actually ended up getting overturned on appeal, and they added 3 years to his sentence. So I was really lucky to be really happy the day I was overturned in that case. But I had to sit and look at young women who will never be the same again. One of them had so much makeup on, it looked like she had a Halloween mask on her face. We're not just talking about how young women look. No, she had built a mask on her face. And the asshole defense attorney called her back just to say, well, you had sex with him later, right? Yeah, I was afraid of him, so I didn't dare say no. Yeah, but you didn't say no, did you? No. Oh, so you didn't claim that was rape? Oh, shit. No, now I said it. No, I didn't. Oh, okay, that's all. And she was so scared, she could hardly take a breath in court. These are the things that you sit and look at. It's easy to sit here, we make fun of it, and yeah, and in a perfect world, and I would have done that, and I would have told my kid this. But in reality, you have to sit and listen to what's said in court, and you have to try and put yourself at the scene and think, what happened? It's not always fun. Some of them you remember for the rest of life. This grape case is probably 8 years since I had that. And I can remember the face of every young woman who sat in front of me that day. I remember the name of my first CP case. First time I had it, and she had the same name as my daughter. Don't forget that one. The testimony of a 14-year-old who was raped by a 44-year-old man, alcoholic, fat ass. Remember her testimony as clear as day. It's not fun being a jury. It's really easy to sit and watch it on a distance and say, well, they should have done this. They probably had all of these discussions. They deliberated for 11 and a half hours. And I don't think they were right, but that's the verdict. And the jury is always right. That's the justice system.
You did miss it, MG. It was not guilty.
Not guilty on all the intentional, but hung on all the lesser included. Because they were not guilty on all, do the lessers on count 4, 1, I thought. What? I'll have to see if we can get a rundown of the verdict, because I think we are all kind of confused on how much the state can go back and charge him with again.
Yeah. I mean, I am.
Yeah, Elizabeth, you see more stuff than we always yell at Trooper Proctor and all of these assholes, but we have to remember some of you are the good eggs, and you do a lot of bad stuff. Well, you don't do a lot of bad stuff. You'll handle a lot of bad stuff. And thank you for the work you did. No, you get some power, and you have. That's the first thing I thought about when my first case was 4 girls who had beaten up 2 other girls, and that's 15. I think it's 15 years ago now. And my thought in the middle of it was, oh my God, I get to decide what's going to happen with these girls. I better take this seriously. And one of them was sent to a youth facility for 3 years. Well, so that's something. Yeah, he was overcharged. I still say they can't, but we all know Baker doesn't like to listen to me. No, but I can't read what you're saying, because they were not guilty on all. Do the lessers on count 4, I thought. Jamie, what does that mean?
I don't know.
And most of the lessers on in count 1. I believe you on everything, but I just don't understand. Marissa, you always complain when I write, hey, it's your, not you are. It's not are. Well, I'm dyslexic. I don't understand what she's writing, but I don't want to say it. And now she comes in here and I have to yell at her. Marissa, do your job. Yell at Jemima for me. Well, that's not my job. I'm going to yell at you.
I'm thinking
Well,
she's still
tough
saying the
beans.
same thing she said earlier, which was if the lessers have the same charge, like the same elements or something, you can't just recharge them on them.
No, and that's how I understand it as well. But then I just don't understand why she only declared mistrials on 2 of them. That's the thing we are confused about. And MG, yeah, I totally agree. If you want to charge, you charge. If you want to say murder, murder. You don't get murder or maybe manslaughter, or maybe you just went down the wrong alley. Hey, it happens. Charge or not. Yeah, well, again, we don't have to agree on this channel. I am not with you. I would have found him guilty of intentional, unintentional manslaughter, because I don't think he had any right to go back and stab him at that point. I would have said self-defense on the 3 assault cases, but the manslaughter I can't get around. Lawn and Crim seems to be confused as well. No, I don't. That's not the one I want. Lawn and Crim says, on Wednesday, Raul Valle was found not guilty of murder in the death of 17-year-old Jimmy McGrath on May 2022. The jury found Valle not guilty on murder, manslaughter, and assault as to Jimmy McGrath, and were hung on the other assault charges. No, that's not what they were. That shows us we are all bewildered with what this judge said. Because the assault charges were on the 3 who lived. So this just shows we'll keep an eye out and see when someone smart breaks this down. MG, if you're doing a show tonight, you have something, go back and listen to the verdict and explain it to us.
Yes, please.
They should just offer him some probation community service and not bring this to trial again. I don't know if they're gonna bring anything. He said they were gonna do it, and she said, well, let's hear the verdict first, but that's the thing. Oh, there was a lesser included in count 1 of assault. Thank you, Jemima. Yeah, but still, he chose to bring a dangerous weapon to the fight, and it's okay to fight, but it's not okay to take someone's life, and that's the thing. You'll forget to do it. Make Jemima your mod, and she will yell at you until you cry on the floor.
No.
That's what she does to me. Everyone, I'm confused already. I will try and do some research and find out what it really means. So I'll probably make that into a video tomorrow if I get some clarity. Not Claritin. That's for my bad skin. Jamie, thank you for showing up. Chat, thank you all for showing up. Jamie agrees, I disagree, but we all respect that the justice system has spoken. We'll find another trial another day. Have fun out there. And remember, no matter what, just come back, follow us on Discord, follow us on the Twit, and hit the likey poo or something. Jamie, anything you want to say?
No, just this was fun. And join the Discord. We'll have fun in there, and everybody have a great day.
Yeah, join the Discord so Jemima can yell at you instead of me.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
Checking your honor.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you?
We finished all the hearings in the Brian Walsh case.
Slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there-
Everybody has.